So in terms of my research that I've been doing is on the characterization of privacy that the Supreme Court did, starting with the Fearon case. And so my question is, should the Supreme Court recognize the technological implications or the information contained in a cell phone? I believe that this question is important because, as we've known, technology is placing a larger role in our day-to-day lives. And in terms of Fearon, the court had an opportunity to set clear protocols, which they did not. And obviously Fearon is a criminal search case, as in criminal searches and charter cases, the court looks at the search after the fact. And was this reasonable? Did the state go too far is the main question that the court has. So the case of Fearon, the cell phone, and when the Supreme Court talks about computers, it's a different standard. And my question is, why is it a different standard? Why is there a different standard? I know you just read Fearon last couple of weeks. By way of a little bit of background, for people that might not have read it, armed jewelry heist, 2 young men armed with a gun. So a woman was putting jewelry in the trunk of her car, and she is robbed at gunpoint. The 2 robbers jump into a car and take off. And this woman loses about $10,000 to $40,000 worth of jewelry. A 911 call gives the license plate, this general description of these young men, and off they go. So one officer who heard the radio call believed he knew that had a hunch that one of the culprits might be Mr. Fearon. So he does go to the last known address of Mr. Fearon, and lo and behold, Mr. Fearon rolls in with Mr. Chapman, and once they leave the apartment building, they get arrested. So Mr. Fearon has a cell phone in his pocket, and that is where the fun starts. So the officer on arrest scrolls through the phone and notices some text, one text that wasn't sent that said, basically, we did it, and some photos of gun and mail. So I don't know, there's a lot of cases where young men are posing with guns and leaving them on their phone, so that's never good. And there was a car nearby that was connected to Fearon, and pursuant to a search warrant, they found a gun in the car. And at least at the trial stage, the trial judge believed that the picture of the gun and the gun that was found were the same gun, or the same type of gun at least. And a later search of the phone didn't really reveal anything else. So we have the text, we did it, and the photo of the gun, and Mr. Fearon and some other young men. At trial, the defense sought to exclude the evidence, although they didn't challenge the arrest. And if I didn't make that clear, it was a search incident to arrest. So the trial judge said that the search of the phone, no breach of Section 8, and we are not excluding the evidence. And the Court of Appeals said the same thing. We get to the Supreme Court, and Cromwell, writing for the majority, the same question: was the search incident to arrest reasonable? And should this evidence be excluded pursuant to 24(2)? And search incident to arrest, as you may know, is a warrantless search, but it is allowed for certain purposes. That is the safety of the person or the officers, to gather and preserve evidence, and as a tool to find any tools of escape. And overriding the search incident to arrest must be a reasonable objective for the search. Not only do they search the person, they can search the surrounding area or the things located around the person. But a cell phone there's nothing really dangerous about a cell phone other than you're throwing it at someone. It could be used to summon help, of course. And it's funny how a lot of the cases talk about someone being able to, remotely wipe out their phone. Yes, I mean, that's a possibility, but I don't believe, I would be my submission, that's not necessarily something that we would do generally, right? Given all that we keep on our phones. So the cell phone that is searched in the photos and the text, we now get to the question that I believe that the Supreme Court didn't really answer is, should there be a distinction between a cell phone and a computer, and what kind of privacy interests are we really dealing with? So, stepping back away from the cell phone for a quick minute, in terms of computers, the court has found that a workplace computer, there is a high biological interest in your workplace computer. If you use your workplace computer and you go home. And a lot of these cases, unfortunately, or fortunately, have been child pornography cases or other kinds of information on the computer. And obviously with the personal computer, there's a high biological aspect to it. Quoting from Cole, this contains information that is meaningful, intimate, and touching on the user's biographical core. So why do we not get that in a cell phone? Privacy is assessed on a sliding scale. So when we're talking about Section 8, privacy interests, we are talking about 3 different areas. Is it territorial, trespass, a place, a location? As you know, the home is still sacred. None of us spend any time at home anymore. The other one is informational. What is being told about me that I don't want to get out there? I'm watching cat videos, things like that. Third, the biographical aspects of me, and going from fingerprints, voice identification, if not quite a voice print, blood samples. And as we get to more, I don't want to say intimate, but once you start taking blood samples, that I have a high personal interest in blood that's taken from me and what it could reveal. And then the other question is, does the claimant in the particular case have a reasonable expectation of privacy? Is it reasonable for them to expect privacy in this hotel room? Is it reasonable to expect privacy in a locker, per se? Is it reasonable to expect privacy in their cell phone? Although the Supreme Court in Fearon acknowledged that, yes, there's dignity and integrity that is connected with searching someone's cell phone, they don't take that next step to say this is biographical, and so much so that a search warrant is needed. This is the majority. And in fact, Cromwell at one point says, this is hardly a massive invasion of privacy. What's a couple of texts and a couple of photos, right? That's not the right question, I would submit. It's whether the police should be able to search through a phone without a search warrant, even within a search incident to arrest. Another issue in Fearon that I find interesting is the police's categorization of their search. And for Fearon, they look at the phone at the scene. The police go back to the station and they scroll through it again and again, and over the course of a few hours they sort of look and see what else they can find. And so it's a continuing look through this person's, Mr. Fearon's phone. At each level of court, they mention this cursory search. to this day, I don't know what cursory means. I mean, I know what cursory means, but cursory can be 2 seconds or it can be all evening. And the Supreme Court doesn't try to rein them in and say, listen, how long were you searching? What did you in fact do? And the other issue is that and something I'm just going to at least mention is the law enforcement, the state interest in dealing with the recent robbery, the use of a gun, was given more priority than Mr. Fearon's rights. That's pretty obvious. But here the Supreme Court could have didn't find anything wrong with the search, and decided that search incident to arrest were not going to change the police's powers to search a cell phone if found on the accused person. But they also sort of give this sort of mealy, well, we're going to ask the police to have some sort of a reasonable objective that they can point to, and we're going to ask them to write down what they've done. But what if they don't? What if they don't write down what they've done? Is there any levers that the courts can say, you didn't write down, how do we know you did what you said you were going to do? Obviously, it's pretty obvious if they do a complete big data dump, because that's usually part of the disclosure that we're given. But the court could have said, this is how we set this up in the future. Why this is important, why I believe that Fearon is important, is obviously for cell phone privacy, but for what we're going to be doing in the future. What kind of technology do we have in the future? And I'm talking about the personal technology, and I know both professors were talking about, well, certainly the first talk about, this overriding government interference with things. But going back to what we have at our home and what we carry with us, our, Google Glass, or what are the other ones I came up with, our GPS, or Fitbits, our Amazon Echo. Yes, there's what we say and what we hear, but there's also going to be, what we're asking Amazon Echo to do. Amazon Echo, find me the latest, who are the neighborhood assassins or something, right? Smart cars. Yes, maybe these won't impact on our biographical core per se, but they're certainly going to reveal a lot about us that we might not want to get out. And then what's out there in the cloud, all of this stuff is uploaded into the cloud. So all of these different pieces of technology is really giving a really fulsome picture of us. And we don't have a way to rein the state in. There was a recent case, and you might have studied, in terms of text messages. So my text to any one of you is private, even though it's in your phone, but the cell phone isn't. And so this is my issue or my argument. There's a recent Supreme Court case, I believe around the same time as Fearon, from the US in Riley, called Riley, R-I-L-E-Y, where the police traffic stop. Mr. Riley has a couple of loaded handguns in his car, a flip phone, remember those? In the flip phone, there's still pictures. There's texts that indicate he might have been a Blood, which is a California gang. And there was pictures of him by a car that was involved in a drive-by. So Mr. Riley gets found guilty and is sentenced to about 15 years. And this case goes all the way up to the Supreme Court, and this was a search incident to arrest case. So the Supreme Court, at that point, and Chief Justice Roberts indicated, in this great quote, noted that 90% of adults in America essentially have on their person a digital record of nearly every aspect of their lives, from the mundane to the intimate. A detailed examination of a cell phone is analogous to an exhaustive search of an entire home, and in fact reveals more than what could be found in an exhaustive search. So clear recognition of what is on a phone, and this is a flip phone for goodness sake, and found that always there would need to be, when search incident to arrest, terms of a cell phone, there needs to be a warrant. And the dissent in Fearon basically says the same thing. So where do we go from here? There are no clear guidelines yet in terms of cell phone searches. In terms of computer searches, VU is probably the best. There's another case, TELUS, which is with regard to production records from Rogers and TELUS in terms of phone records. And the court in that says that when officers are drafting those search warrants, they should really set out and do an incremental advancement in terms of the information they're asking for and what they're going to search, and clear protocols were set there. Here, there are no clear guidelines by the court, as far as I can see, and so I would submit we're going to do this ad hoc stumble from case to case, technology to technology, until something comes up that is clearer. So the journey continues.